Salman, thank you so much for making the time to speak with us this afternoon.
It's my pleasure. Thanks for having me.
Yeah, so um, as a member of our distinguished panel of neutrals, we have been featuring some individuals who have really interesting backgrounds, and we want to introduce to the larger community. So I know that you work primarily as an advocate, but have incorporated professional neutral work into your practice. And I'm wondering if you could talk a little bit about the path that led you there.
Sure. Thanks again. You're correct in that my practice is that of counsel. I currently serve as counsel to parties in state court, in federal court, at mediations, and in arbitrations. But I also have been doing neutral work for a number of years as a mediator and as an arbitrator. And I've been privileged to sit on both sides of the table, if you will, having been in the war room and in the courtroom, understanding businesses' concerns from my own docket, from my own clients, and the way I interact with them as counsel, and to understand mediation and arbitration are the way of the future. Um, Especially in the commercial context, you have my work involving uh, businesses that may have been formed decades ago by family members, or a executive, a CEO, for example, reporting to a board of directors, seeing what sorts of pain that they go through in disputes, and understanding that ADR could provide a resource for not only those individuals, but also the businesses and the nonprofit organizations and the boards that I serve as counsel to. ADR just seems to make sense. I was privileged to be a law clerk. I also had an opportunity to work in the legal department at the United Nations Office of Legal Affairs, and then participating in the working group that was crafting the Singapore Convention on Mediation. So I felt my work was aligned with resolving disputes in a fast and efficient manner. And I wanted to be there for clients, and I understood what they were looking for, which is get back on track, get back to their business. And they want to make sure that they can do so fast, efficiently, but also in a confidential setting. And that's why ADR makes sense to me. It saves time and money, and it often meets the business's needs of confidentiality.
So it sounds like your work as an advocate has really helped you sort of absorb the business case for alternative dispute resolution, and has made that a sort of attractive professional focus for you.
Absolutely. I've had this opportunity to be in chambers with judges to learn and hone my legal writing skills, my presentation skills. And those are all skill sets that everybody participating in quality, sophisticated, complex disputes has already. But having that opportunity to sit as a neutral on the other side, I understand what counsel is going through. I understand what the parties are going through and what they're looking for.
So you work both as an arbitrator and a mediator, and those are really different processes. Can you talk a little bit about what you like best about the arbitration process and what you like
Mhm.
best about the mediation process?
Sure. So, look, I'm a process neutral in that I like systems and I like organization. Um, I understand, of course, arbitrations and mediations must have a flexible component to them. But the very idea of moving a case along, of being able to give the parties a roadmap so they know where they're headed, and they can then communicate to their clients and ensure that they understand the arbitration process is very important to me. We've all heard the term justice delayed is justice denied, and everybody talks about the backlog in the court system, especially post-COVID, whether they're domestic disputes or international disputes. So I enjoy providing parties this sort of an outline, if you will, and a calendar that all of us can follow to ensure that their dispute gets a result. Um, with respect to mediation, of course, I enjoy the flexible process. Um, I enjoy the creative solutions that I am being empowered to by the parties to help them come up with. And a sense of fulfillment, right? I, in mediation, look at my interaction with people. It's not the litigants, it's not the parties, it's not the lawyers. It's people with conflicts and people with disputes. And once we're done with mediation and crafting a solution that they've come up with, we've moved one file over, one conflict less on their desk. And that is a important sense of fulfillment, the ability to create results-oriented solutions for the parties, but also for counsel because they want to move along the files.
So we've just heard about what you find satisfying and fulfilling about these two processes, but they are complex and sometimes thorny processes. Are there any challenges that you have encountered as you are leading an arbitration hearing or a mediation session? And if so, how do you manage those challenges?
Sure, the technological advances that we see just every single week change with ChatGPT, artificial intelligence, keeping up with the technological tools that I employ in my arbitration hearings, for example, learning the tools to have remote hearings, to preserve confidentiality, but also to exchange exhibits and allow witnesses to participate, for example, in different not only cultural contexts in person, whether they're traveling from overseas or domestically, but also using certain technological tools, right? So keeping up with technology is very important for me to ensure that the parties can use a neutral that not only gets the law, but the legal sort of what lawyers do day in and day out, right? They understand the issues, they write them out and they brief them out and they argue, but also can we present in an efficient manner? Can we request the adjournments that we may need to make sure the process is flexible? And all of that with technology shifting is attending CLEs, for example, is very important to me. Communicating and having a network of other neutrals to rely on, being a part of practice groups. You have to just stay on top of it. Otherwise, you're old news. And I try to do it, keeping up with technology is very important for my neutral practice.
So we've talked a little bit about how, because you work as counsel in a variety of contexts, you sort of know what counsel is going through. Do you see any common patterns of mistakes that counsel make in these processes? If you could sit counsel down before an arbitration hearing or before a mediation, and had an opportunity to advise them how to best deploy the process, like what are those mistakes you would tell them you see that they should avoid?
Yeah, look, for any trial lawyer, anybody arguing before a tribunal, before a trial of fact, calendar management, I believe, is a crucial skill set, right? Same thing with arbitrations. Calendar management is very important, and preparing for a hearing happens at the forefront. Lawyers get it, they understand it. That's the obvious. I think it's also important for counsel to ensure that their clients understand the process, to have an honest conversation with them about case management conferences, about what the roadmap in an arbitration looks like, because while counsel may understand how arbitrations work, their clients may not. So having an opportunity to speak with them, to ensure that they understand the process is important. If I could sit down counsel that participate in arbitration, one thing I would say is don't be shy to ask questions. This is your process. This is your dispute. Ask clarifying questions. Many arbitrators don't build in enough time at the pre-hearing stage of their conference at the beginning to ensure that there may be open questions that the parties want to ask counsel want to ask, can we build in certain check-ins, or can we have certain conferences on certain issues? That's very important for me. And so I would advise counsel not to be shy. Ask the arbitrator up front so there aren't any surprises for them, for me as the neutral, and also the administrating body. Similarly, I think for mediations, right? So much weight is put into neutral selection. This idea of picking the right neutral and doing your research. And look, any qualified counsel will do their vetting, will ensure that they've picked a qualified mediator or an arbitrator. For us neutrals, there's a rigorous process. If you're on the panel, you've already sort of done a lot of your training and you're qualified. One thing I would say is for counsel to seek mediators that are creative, of course, but that are also patient. And lastly, that can be available and accessible. And what I mean by that isn't somebody that can be available to do your mediation, but somebody that can roll up their sleeves, and when the first mediation fails or the second mediation fails or needs more time, can on their own follow up with you in a few months or a few weeks, or when you wish, after discovery closes perhaps, or prior to the beginning of trial, to check in and to offer that opportunity and be really invested in your dispute. That's a good mediator. And to look for people, again, that are creative, patient, and accessible.
I've heard that one description of really excellent mediators. They're like the Energizer Bunny, and they don't give up, and their motor is always running, and they're always thinking, how do we get this case settled? So just because maybe the session is over, that doesn't necessarily mean the mediator's involvement in the case is over.
Right, and finding that balance, right, when one of the parties wants to settle and the other party has made it very clear that, we're done, and we have to be mindful and respectful of the party's wishes. Again, it's their process, and then bridging that gap to make sure they can actually appear, even if they say that they're done, and knowing those cues and engaging in that active listening through words and actions in a case.
So excellent people skills.
Oh, for sure. Not always easy, but it's a process that you build trust with the parties that you work with. You have trusted relationships, and they like your work and they'll come back.
Great. So, as an arbitrator, what are your views on discovery and dispositive motions? I mean, you've talked about the importance of creating a sort of streamlined process that moves the case along.
Mhm.
How do dispositive motions and the counsel's request for discovery fit into that?
Yeah, look, the hallmarks for arbitration for me again are efficiency and fairness. You want somebody that's again well versed in the law, but also prepared to run an efficient hearing. Um, But when it comes to dispositive motions, look, my philosophy is if the rules allow it, I allow it. I take certain things into consideration. I want to make sure that parties have an opportunity to present a question to raise dispositive motion. Um, and I have to balance relevance of those motions. If they could eliminate certain issues at trial or at a hearing, that's important for the process. That's what they've signed up for arbitration for, to ensure that it's a cost-effective process as well, that we're not filing frivolous motions if there isn't a need to. So I look at the timing of these requests. When are these dispositive motions being raised? Are they sort of at the beginning? Are they at the tail end? Have we already done a lot of the work and it's ready for a hearing anyways? And then I also look at frequency of these dispositive motions. Are they being raised frequently or often? And is this still a process that's being managed by the neutral, by me as the arbitrator, in what the parties have signed up for, which is for it to be a cost-effective process. And if there is relevance, then we entertain it because the rules allow for it.
Great. So, I understand that you've served as a neutral for a variety of nonprofits. Can you talk a little bit about the kinds of disputes that arise in that context? And if you do anything differently when you're working with a nonprofit as opposed to a commercial entity?
Sure. Nonprofit disputes relate a lot in my practice to governance, um, to election disputes and bylaws. So I offer this sort of, it's not very popular, but these election supervisory services, right? Managing ballots, but also advising on bylaw issues when there are elections that need to happen, for example, or if there's an employment or a labor dispute within a board or executive staff and there's change at the higher levels. That is often when there are disputes because often these nonprofits are founded by folks that have been engaged in the organization, similar to a business, and it's their baby, and they want to make sure the succession or the transition that's going to happen happens smoothly. So I see a lot of bylaws disputes, a lot of election supervisory work, but also your typical A through Z, commercial breach of contract disputes within the nonprofit setting, employment disputes, severance disputes with nonprofits. And my view is the same for the for-profit and the nonprofit clients, is that we have to promote ADR. If there is a mechanism to use mediation, we do that and really ensure that you hear the parties' concerns at all stages of the process.
I see that you've, in addition to your work as counsel
Mhm.
and as a neutral, that you've also founded and participated in a number of scholarships and education-oriented initiatives. And I'm wondering if you could talk for a minute about, well, first describing the projects and then why you got involved with them.
Sure. Well, thank you very much for asking about this. All of us do amazing work at the office and in our professional lives. And at least for us lawyers, it's very important for me to be a lawyer, but also to be a leader in our community and to give back to those that are underprivileged. I'd like to promote the idea of young people attending law school. Um, but access to education has changed my life. Access to a legal degree has changed my life. And it's used as a tool to provide access to justice for me. The idea that you can speak up for somebody, the idea that you could stand up for somebody because of your legal background is so enlightening. I want others to be able to pursue a legal degree because I understand how important it is. And so my scholarship work surrounds raising funds uh, by individuals, by corporations, by governments, and to engage in work that says, well, we've got an issue here. We need to ensure that young people can go to school, can graduate on time, and be an active member of our communities. And that is so in line with being a lawyer for me and leading in our community that I do it. I hope more young people attend law school. Maybe I'm being biased here, but I enjoy law practice, and it's certainly something that I hope to continue to do for the rest of my life.
Well, that's inspiring and an inspiring message for everyone in the CPR community. So with that, I want to thank you for speaking with us today and making time in your busy schedule. And we look forward to seeing you at more CPR events.
Thank you so much for having me and for including me in this initiative.